I think we can give it a go. We still got people coming in, but we already have 100 people in the audience, which is amazing. Welcome everyone to our lunchtime seminar on the prosecutions under the Modern Slavery Act. We are the Modern Slavery and Human Rights Policy and Evidence Center at the University of Oxford. And my name is Jakub Sobik, and I'm a communications director at the center. So the topic, prosecutions under the Modern Slavery Act. One of the key aims of introducing the Modern Slavery Act in 2015 was pretty explicitly to make prosecutions easier. And it is to that end that the Act consolidated and clarified offenses gathered under the umbrella of modern slavery and increased the penalties for these crimes up to life imprisonment. The Act also introduced measures such as confiscation of traffickers' assets and prevention orders to restrict activities of suspected perpetrators. So 10 years on, it's a good time to take stock on how they went. And I want to reveal huge surprises when I say that the rates of prosecutions and convictions remain very low. And this is what we talk about in the report that we published last Friday, analyzing what's gone wrong and well for successful prosecution since the Modern Slavery Act. And what are the main barriers to improving them? And when I say we, I mean Dr. Alicia Heys, who carried out this research. She is a senior lecturer in modern slavery at the Wilberforce Institute at the University of Hull, which is part of the Modern Slavery PEC. And she's the co-investigator of the PEC on behalf of her university. So today we have Alicia to talk us through the findings of her research. And before I give you the floor, Alicia, it looks like we ticked the wrong box in terms of allowing the cameras on. I'm not quite sure that we can do that, so apologies for that. But if you want to ask a question, we can still bring you on screen afterwards, and we'll have a proper look afterwards what we've done wrong. But Alicia, the floor is yours for now.
Thanks very much, Jakub, and thanks everyone for joining. Like Jakub said, I can't see anybody. I'm not sure if that makes it more intimidating or less intimidating. So I'm going to talk to you for about 15 minutes on the report that was published last week, and just starting off by sharing the screen. So as Jakub's introduced, this is all about barriers to prosecutions and convictions under the Modern Slavery Act, and is a piece of work that I've conducted on behalf of the Modern Slavery Policy and Evidence Centre. In terms of what we were looking for, initially this piece of research wasn't undertaken to investigate the prosecutions. It was a piece of research about using financial investigations as a means to reaching prosecutions. But in doing the research, this topic about the problems of getting the prosecutions kept coming up time and time again. So we've ended up dividing the research into two reports, and this is the first report that's come out of it, with a following one to come on later down the line, and I'll talk about that a bit at the end. But in terms of framing this report and what are we looking at, what is the problem, we're looking at the Modern Slavery Act 10 years after it was introduced, and how the prosecutions and convictions specifically under that piece of legislation continue to be relatively low in terms of the number of victims that are being identified. We're also seeing that the sentence lengths coming from the Modern Slavery Act, in the context of having a maximum sentence of life imprisonment, don't necessarily reflect the severity of the crime in a lot of instances. And we're also seeing there's a really strong reliance on survivor testimony in the criminal justice system, in terms of prosecutors relying on that survivor testimony in court to be able to get to a prosecution. But we're identifying that there are lots of barriers that prevents that survivor engagement, which in turn then prevents a charge from getting to a conviction. So in terms of what was done for the research, first of all, it was a review of academic and grey literature around modern slavery prosecutions and convictions. And for anybody that's tried to investigate finding these rates, I'm sure you'll understand the time it took and the digging into spreadsheets involved in trying to make the dates match up. So looking at CPS statistics, the Crown Prosecution statistics, and Ministry of Justice statistics, particularly in comparison with National Referral Mechanism statistics. I also undertook interviews with 15 different practitioners who all had some experience around the criminal justice system, modern slavery, prosecutions, convictions, and obviously because of the initial intention of the research around financial investigations as well. So like I mentioned earlier, this is the first in a two-part series, and the second part will be focusing on those financial investigations. And then in terms of what was found, this first slide is just specifically around the statistics. And I have thrown in some underlines here because there is some differences between where the statistics relate to. So the first point comes from the Modern Slavery and Organised Immigration Crime Unit, which reported that there were at least 2,497 modern slavery and trafficking investigations being undertaken at the time of June 2024, and this is across the UK. But in the timeframe of July 2023 to June 2024, the Ministry of Justice noted that across England and Wales, they saw 114 defendants who were proceeded against for modern slavery offences, 58 were convicted and 58 were sentenced. And that average sentence length that was handed down was 5 years and 3 months. And again, this is in the context of the maximum sentence being life. Now, in that same time frame of July 2023 to June 2024, there were 17,120 people referred into the National Referral Mechanism. But again, that's across the UK. So when we're looking at those 114 defendants, we have to bear in mind that that is not directly linked into that 17,000, which is across the UK more broadly. In terms of key findings, you can see from those statistics that convictions under the Modern Slavery Act do still remain low in comparison to the number of potential victims identified and referred to the National Referral Mechanism. And I think when I'm talking about this key finding, it's probably something that is not a surprise to many of us who are working in this field, and I'm not really telling you anything you don't already know. But these second two findings are perhaps a little bit more detailed. So one of the things that we picked up was that survivor engagement is often considered essential for getting a prosecution and a conviction under the Modern Slavery Act, but there are a lot of problems in terms of maintaining survivor engagement. And there are a number of reasons for this, and they're not all necessarily specific to modern slavery, and there is quite a lot of academic literature about the barriers to survivor engagement in the criminal justice system. But some of the key things that came out in this research in terms of the barriers to that survivor engagement related to poor support to encourage engagement. So this might be common when a criminal justice professional has a different timeline to a survivor, where the survivor does not necessarily want to engage immediately with the criminal justice system, but a police investigator or a legal practitioner might be working to a deadline where they're trying to push this prosecution through. Fear is a really common one, and again, I don't think is going to be a surprise to many people, but here we're talking about fear not only in terms of potential reprisals from the traffickers, in terms of not only fear of the trafficker identifying them or their families and threats or actual violence, but there's also a fear of arrest. And this is especially true in situations of criminal exploitation or sexual exploitation, where the survivors have previously engaged with the criminal justice system, but where they've been treated as perpetrators or offenders as opposed to victims. And then the final part of fear is a fear of deportation. And this links very closely to the immigration work that's just been published by the Rights Lab and the Independent Anti-Slavery Commissioner's Office. So I'm not going to go into too much detail there because there's a separate report you can read on that if you want more detail there. Stigma and shame was a topic that came up a lot as well in terms of ways that people were responded to as survivors of modern slavery and human trafficking, and especially where we're seeing deception and fraud and coercion and people feeling ashamed that other people will see that they've been deceived or have fallen for the traffickers' tricks. But there's also an issue with stigma and shame when it comes to some of the language used around modern slavery and human trafficking, and especially where there's controversial terms still sometimes used problematically, things like child prostitution. And the kind of wording that implies that there is some accountability to be held by the survivors themselves, which really doesn't recognise the experiences of modern slavery. There are also some problems with assumptions around how survivors should present, and this ties into this notion of the ideal victim and what society is more likely to accept as a victim or a survivor. And if somebody doesn't necessarily meet those conditions, then they are less likely to be identified or responded to as a legitimate survivor. And then there's a really practical barrier is language barriers. If people can't explain their own experiences clearly to somebody who can understand them, then this is quite obviously problematic. And then, so that finding was more based around what prevents the engagement from survivors with the criminal justice system. But there was also another key theme that came up, which was about the institutional limitations that can reduce the effectiveness of the legal enforcement. And again, I'm afraid a lot of these things are things that have been reported on quite a lot in modern slavery research and probably not new to many of you. But it's the findings, so I'll tell you about them anyway. So one of the main things was a lack of understanding of the nuances of modern slavery cases. And when we're talking about completely different types of exploitation, from labour to exploitation to criminal exploitation to domestic servitude to sexual exploitation to organ harvesting, there's not going to be a commonality between the experiences of everybody who is a victim or a survivor of this type of crime. So understanding that people are going to present very differently depending on their experiences is really important. Insufficient resources, I think, is something that comes up in pretty much every piece of modern slavery research in terms of lack of funding or lack of training for practitioners working on these really complex issues. And then in terms of complexity, modern slavery investigations are hugely complex and hugely time consuming. If we think about the amount of data that is required, not only in terms of survivor or witness testimonies, but accessing things like CCTV and phone data, where downloading a phone and going through all the text messages and translating messages can be massively complex, massively time consuming, and massively resource draining. But that length of time can be really problematic in terms of maintaining that survivor engagement as well. So if you've got an investigation that takes 5 years from it being reported to getting to trial or getting to court, then we've got the problem not only of maintaining engagement with survivors in updating them and what's going on, but also that those survivors' priorities are likely to change in that massive time frame. And it could be that at the beginning they were willing to be involved and wanted to support the criminal justice process, but as years go by, there was research to suggest that priorities change and that perhaps they are less invested in pursuing the criminal justice process when it's taken so long, and more invested in continuing to change their priorities and progress in their new lives. So continuing building friendships and relationships and families and getting jobs where the criminal justice process becomes less of a priority for them. So the final point is the criminal justice outcomes for survivors were further compromised, particularly by low sentences and offences being charged under other legislation. So in terms of low sentences, when survivors are seeing their traffickers, their offenders, the perpetrators being sentenced for exploiting them, and the sentences are relatively low, this risks other survivors being perhaps less inclined to pursue the criminal justice process when the sentences don't reflect the severity of the experience that they had. One of the other things that came up, which was really interesting to me and is not something I'd particularly considered before, was that actually we are seeing some of those offenders charged through the criminal justice process, but under legislation that's different to the Modern Slavery Act. So there were quite a lot of examples discussed in the interviews where we saw offenders being charged under other offences, so things like drugs offences. And while this can be positive in terms of, well, at least the offenders were held accountable to some extent, some of the problems relating to modern slavery offences are that it can misrepresent the survivors' experiences. So if the conviction is pursued under prostitution for gain, for example, then this represents the survivor as completely different to being a victim of modern slavery. And there was a really good example provided in one of the interviews where that change in how they were presented made that survivor find it really difficult to come to terms with how their perpetrator was held accountable and how they were presented as a victim of this perpetrator, which changed how she identified about herself and how others reflected with her. One of the other things that's problematic is the Modern Slavery Act has specific, really helpful ancillary orders, like the Slavery and Trafficking Prevention Orders, the Slavery and Trafficking Risk Orders, and the Slavery and Trafficking Reparation Orders. But these aren't available if you pursue the offences under different pieces of legislation. So there are gains that could have been made that can't be made if that offence is prosecuted and charged and convicted under another piece of legislation. And then finally, it blurs the figures around modern slavery offences. So where we're seeing that the Ministry of Justice statistics are saying that 58 people were sentenced for modern slavery offences. Actually, when we look at the broader statistics from the Crown Prosecution Service, there are many more flags that show that prosecutions have been made for modern slavery offences, but they've been pursued under different legislation. But the problem with this is that it can mean that the modern slavery investigations aren't funded or prioritised because it looks like there are fewer modern slavery offences that are represented in those figures. So in terms of what should be done, I think there's about 21 recommendations at the end of the report, so I'm not going to go into all of those, but I've grouped them into some key areas. And the first, again, I'm sorry to harp on the same recommendation that's in pretty much every report about modern slavery, is about resources and training. But one of the key things that came up time and time again was the value of victim navigators. And these are roles that sit as a bridge between survivors and police. And there was some really positive feedback in the interviews about how valuable the victim navigator role is and how it's actually worked in a lot of areas to increase the likelihood that a report of modern slavery is going to make it to a prosecution and conviction. The next was to focus on building trust with survivors. And there are a lot of different examples of how this could be done or where the priorities should be placed. But ensuring practitioners know the impact of trauma was a really key one. So there were some examples in the interviews that spoke of cases where survivors presented in a way because of their trauma experience that made their legal representatives consider them to be unreliable witnesses in court because their trauma impact meant that they were struggling with their memories, or they could remember different bits of information at different times. And it was felt that a jury wouldn't respond well to that. So knowing that trauma can have a really difficult impact on the way that somebody presents or the way that their memory is impacted is really important. The hostile immigration policies I mentioned briefly earlier, there is a very detailed report about that now if anybody wants to engage with that more. But one of the other key things to look into is actually, what does a good criminal justice outcome look like to survivors? So for me, when I was conducting the research, my initial stance was, well, of course we want more convictions under the Modern Slavery Act because that's holding people to account. But then I started to question, well, actually, is a conviction the best outcome? And this is one of the things that we want to continue future research with the Policy and Evidence Centre, is actually working with survivors to better understand what that criminal justice outcome should be for a survivor to think it's been successful? Is it about a sentence? Is it about reparation? What does success look like from their perspective? And then finally, reducing that burden that is associated with survivor testimony. So at the beginning, I commented that there was a real focus on survivor engagement being considered necessary to be able to get to a prosecution and conviction under the Modern Slavery Act. But this can put a lot of pressure on the survivors, thinking that their testimony is the thing that's going to get it over the threshold. So one of the things that came up, which is unsurprising considering that the research was initially about financial investigations, was the importance of using non-witness testimony. So corroborative evidence, things like financial records and digital records, CCTV footage. One of the real issues here is proving that that level of exploitation in a modern slavery case, because you can prove that someone's been moved, you can prove that someone has moved money, but you need to be able to prove the exploitation element, and that is where we need to dig into the financial investigations and how they can be used alongside other corroborative evidence to take that burden off the survivor testimony. And again, this is another thing that we're conducting research with the PEC. Another thing is to ensure that special measures are always offered to survivors in court settings. So things like being able to give testimony via a video link or behind a screen, to make sure that that extra pressure of testifying in front of a perpetrator is removed. And again, is another thing that comes up in a lot of modern slavery research is the strength of multidisciplinary partnerships, where NGOs, police officers, financial investigators, lawyers all come together to share expertise. And I don't think anybody can underestimate the value of an effective multi-agency collaboration. In terms of what's next, we do have more research coming, and some of the work that the University of Hull and the Wilberforce Institute, as part of the Modern Slavery Act, will be focusing on is understanding those challenges that are faced by survivors in engaging with the criminal justice system. So what is their perspective on the issues that we've presented today? And again, what that successful criminal justice outcome looks like. And we also want to research financial investigations and how they can be used to reduce that burden on survivor testimony. And then a focus on the Modern Slavery Act ancillary orders, how they're being used and how effective they are. And then finally, an exploration of the Modern Slavery Act statutory defence under Section 45 and the professional perspectives on how that's used. And that's the element of the Modern Slavery Act that provides a defence for victims and survivors of modern slavery who were coerced into committing a criminal offence as part of their modern slavery experience. So I'm going to pass back over to Jakob, having gone over my time, sorry.
Thank you, Alicia, for this very comprehensive overview. Let's jump into questions. I was going to ask the first question, but we've got so many in the chat. So thank you, everyone, for posting them. We've got so many that we're going to jump straight to them, if that's okay, Alicia. I hope it's okay. I'm not going to read out the names, if that's okay, just in case someone wanted to remain anonymous. But there's a question, clarification question. Are the offenses being charged because they are more likely to be successful or more likely to lead to longer sentence, or both? So I think that's the question about using different pieces of legislation to prosecute.
Yeah, thank you. And from this research, that's exactly what we found, is that the Modern Slavery Act required a higher burden of proof and was sometimes more difficult to get over that threshold. So other offences, like drugs offences, were easier to get, and you didn't have to necessarily prove that level of exploitation. So it wasn't that the modern slavery offence wasn't considered or pursued, it was just more likely be successful if it was pursued under other legislation. And again, that's one of the difficulties we've got to think about. Well, what is a positive outcome? Is a positive outcome getting a conviction specifically under the Modern Slavery Act, or is it getting a conviction?
Thank you, that's very clear. The second question, could you advise whether the police have sufficient resources and personnel available to investigate these cases at present? I suspect it might be quite an easy answer for you, but let's see.
Obviously, it's going to depend on the police force, and there are some police forces that have dedicated modern slavery units. There are some that are much more advanced than others. There are some that have more funding than others. There are some that have victim navigators and others that don't. So it's not an overarching answer, although I would say that the general answer and the responses that came from the participants in the interviews was resoundingly, they would like a lot more resources and a lot more personnel. And of course, this research was initially about understanding financial investigations, but one of the things that came up a lot was it would be great to have a dedicated financial investigator for every modern slavery investigation. But financial investigators are like gold dust, hard to come by, and there are few of them in each police force, and they have to deal with all of the cases that are relevant to them. So it's often unlikely that they will be applied to a modern slavery investigation.
There is a career path for those who are looking for a career change.
Although one of the things that came up really interestingly was that financial investigators were so valuable, but then they're not just valuable to the police. So the career path was becoming problematic with the police, that because they're so valuable, the private sector can offer a better pay package, and then the financial investigators may not stay in the police for very long. So this is another thing we've got to think about when it comes to resourcing and making those posts really competitive and valuable so that we don't lose those really important posts.
Either way, sounds like an option to consider. Let me move on to the next question. Just a bit of a clarification, really. I recall reading some literature that suggested that the Modern Slavery Act was being used as a preferred alternative to charging under other legislation because it carried heavy sentences. But it looks like this research does not reflect that. Can you clarify?
Yes, so I think, granted, it's been 10 years and there's probably been a change in the angles that this has been approached from. But I think when the Modern Slavery Act first came out and we had this maximum life sentence, where previously the maximum sentence you could get for a similar offence was 14 years, that it was pursued, but we've never seen a life sentence under the Modern Slavery Act. And when we are seeing investigations that are taking 3, 4, 5 years to get from a report to getting it to court, it does seem from this research that people are turning away from using the Modern Slavery Act, and those sentences are not getting anywhere near the maximum sentence that could be applied.
Thank you. What impact does shifting from victim-based testimony to financial investigations on modern slavery prosecutions?
So there's a lot to unpack there in terms of the survivor engagement, and the survivor testimony provides the real lived experience version of what happened to a person in their situation of modern slavery. But engaging in the criminal justice system can be massively burdensome, can take years and years and years. And one of the interviews gave examples of the same survivor being asked to give the same interview 4 times during their police investigation. So the problem with it is that it can be massively burdensome, massively repetitive, and sometimes traumatic when you're having to repeat the same experiences to different people who are doing the same investigation. The positive of something like a financial investigation means that you can dig into corroborative evidence that doesn't necessarily have to draw on somebody repeating their experiences to you. But one of the drawbacks, like I mentioned earlier, is that it is difficult to prove that exploitation, because unless it's captured really explicitly on CCTV footage, for example, or in a text message, that proving where the money has come from, where the money's going, is easy enough to do. But proving that someone is exploited or not paid because they could have been paid in cash in hand is much more difficult. So this is going to be the focus of the next report that we do at the Wilberforce Institute for the Modern Slavery Policy and Evidence Centre, looking at financial investigations, how they work, the successful financial investigations that have led to prosecutions under the Modern Slavery Act without having to rely on survivor testimony, but also what should be looked for and how it can be used to prove that exploitation element.
Thank you again. I had a question and I lost it, but I'm going to find it in just a second. What can direct delivery support providers do to support survivors engaged with the criminal justice systems or process?
I think the priority has always got to be survivor care first, and pursuing whatever a survivor thinks is in their best interests and supporting their best interests. And that isn't always going to be pursuing conviction, but it might be reassuring them that they can pursue the criminal justice system later down the line. It doesn't have to be a time limited, you have to engage with the police in the next 6 weeks or the opportunity's off the table. So I think that reassurance that you don't have to do anything that you don't want to do, and the chance isn't going to be taken away from you if you don't engage with it immediately, is really important. But that connection with the victim navigators, I think, is also really valuable, and something that really did come up from a lot of the participants of the interviews. And fully aware that victim navigators aren't in all police forces, and I'm based in Humberside and we don't have one here. But that value of connecting a survivor to a victim navigator, if there is one, who can properly explain what the process looks like and how they can support and reduce the burden if a survivor did want to engage in the criminal justice process.
Thank you very much. I'm trying to go through all the questions in the chat. I'm not quite sure if I'll be able to ask every single one, so apologies to those who miss out on the question. But I thought there was a little bit of a discussion in the chat about the UK jurisdiction. So no mention here on whether UK has jurisdiction to prosecute. I found that many victims have been trafficked to another country but fled to UK for protection. Whether trafficking takes place outside the UK, no jurisdiction to investigate, prosecute. And there was a follow-up question, kind of clarification. Does the Modern Slavery Act apply to people outside the UK's territorial jurisdiction? How does that work?
Great questions. I'm not qualified to answer them. So I have to caveat that I'm not a legal professional. But I have just seen that Pam Bowen has put her hand up and maybe we'll be able to answer that.
Okay, let me bring Pan on the screen. Oh yeah, here we go. Pam, if you're able to unmute and please come on the screen and ask a question. You should be able to unmute yourself.
Right. Hello, can you hear me?
We can hear you, we can see you.
Hi, I'm Pam Bowen, and I was formerly prosecution policy lead for human trafficking and modern slavery for 18 years. So I think I've sort of covered quite a lot of these over the years. In addition to which, a few years ago, we had a deep dive into some of the challenges faced in bringing prosecutions that we did with both national policing and Cabinet Office. So a lot of these things have already been covered. But what we did find was that there's quite a few potential victims who were referred through the NRM actually received sort of the conclusive grounds decisions that they were indeed victims, but they were trafficked from one country to another country, but then fled to the UK for protection and support. So none of the trafficking actually took place in the UK, and so there was no jurisdiction to prosecute. We can prosecute non-UK nationals, but there has to be some link to the UK for the offence. So either the defendant or a victim needs to be a UK national, or the organising of the offence needs to have some connection to the UK. But in these circumstances, there's nothing that's taken place within the UK, then they're still counted in the NRM data, but we cannot sort of prosecute. I was going to say, in addition to which, I don't know whether you've covered UK prosecutions which are tried in another country where they may take primacy. So cases where we've collaborated with other countries, maybe through joint investigation teams or through transfer of evidence, and where a larger part of the actual offending takes place in another country, but the victims may well have been referred through the NRM here. So there isn't always a direct correlation between numbers of victims and numbers of prosecutions. So.
Thank you very much for coming on, Pam. Alicia, do you want to respond to those?
No, that's really helpful, and it's great to hear the expertise of Pam, who's worked in this area for such a long time, and hopefully answer some of those questions that I can't answer. One of the things that did come up in the interviews relating to that is where we're talking about 17,000 victims and 58 convictions, as they are not directly comparable, because some of those NRM referrals will relate to historical cases. Some will relate to offences that have taken place abroad, and those are examples of cases where police don't have the capacity to conduct those investigations if there are other live local cases that are going to take priority.
Thank you very much. Let's continue. There is a lot of chat in the chat, and there are a lot of questions, but I'm trying to pick up some themes that we haven't discussed yet. One is, have you found the victims of forced criminal exploitation to be less likely to engage with the criminal justice process due to concerns of their own convictions, or what protections are there for them? It kind of links to the question also, a separate question about whether we see prosecutions for particular forms of exploitation being more common and kind of pursued more than others. So one about which forms of exploitation, and also what are the protections for people exploited in criminal exploitation?
Okay, so in terms of the different types of exploitation, that isn't made clear in the data that I was investigating, so I don't have a clear answer to that. But those Ministry of Justice statistics are publicly available. They're in a footnote of the report. So if you did want to investigate the data tables yourself, you can look through those. In terms of those who've committed criminal offences as part of their modern slavery experience, this research wasn't explicitly undertaken with the survivors themselves. It was with the practitioners and looking at their experiences of barriers to engagement. So some of this future research on working with the survivors and understanding the barriers from their perspectives, I'd really like to dig into this in a lot more detail. But it did come up with the research and with the interviews in terms of the reluctance of people who've engaged with the criminal justice system before, but where they've been understood as perpetrators of offences rather than victims of modern slavery. And from previous research that I've done on Section 45 and that statutory defence that supports modern slavery survivors who've been coerced to commit a criminal offence as part of their modern slavery experience, very much touches on that fear that engaging with the criminal justice system is more likely to result in them being treated as an offender rather than a victim. And when we're talking about those special measures in court as well, that's an issue when we talk about those victims who've committed offences, because those special measures aren't always available to them because they're presenting as a defendant rather than a victim or a survivor. So that's another thing that needs unpicking, is going to be a different piece of research.
Thank you. I think we're running out of time, but I think we'll have time for another one or two questions. One is, Did the research show whether wait times for conclusive grounds decisions affect the success of number of prosecutions?
So it's really difficult to know, because when you see the length of the wait of the conclusive grounds decisions, that doesn't necessarily correlate with when the conviction data relates to. So being somebody that's absolutely terrified of maths, I haven't dug into those the waiting times and whether we can look at how they correlate. But it did come up in the qualitative data in terms of the interviews that the length of time, not necessarily specifically to the conclusive grounds decision, but the length of time of the investigations and getting from a referral into the national referral mechanism to getting a case to court, that alone was taking so many years that people were likely to drop out of being involved. So it stands to reason that the conclusive grounds decision could make an impact, but that isn't explicitly addressed in the report.
Thank you very much. I've had one more, and let me just find it. There was some chat about cases in Scotland, which is quite interesting. But there have been so many comments and questions in the chat that it's quite difficult to go through them very quickly. But I wanted to ask you this about the training. Did your research look into the amount and quality of training that prosecutors or judges have access to in terms of modern slavery? What does that look like in practice?
So I didn't specifically research into the training modules that people go through, but the research did dig into other reports which touched on those things. So things like the House of Lords Committee and the 2019 independent review and the 2016 review of the Modern Slavery Act, which all touch upon the need for improved and dedicated training. This research wasn't specifically about the approach of the prosecutors or the lawyers, but in terms of the financial investigations research that's to come, we'll be looking more about the training experiences and needs there. Sorry, I feel like the answer to the last few questions have been, I don't know.
We all want to know a little bit more. I think the chat demonstrates that we all want to know more, and I'm really sorry that we didn't get to answer all the questions. I think we're going to try to look into them still with Alicia after the webinar. Maybe there is a way of addressing them, maybe in a blog or maybe in writing somehow. So we try to look into that. Apologies again, but thank you so much for the kind of lively discussion in the chat. Thank you for asking all the questions. Thank you for coming. Thank you, Alicia, for presenting and responding to all the questions. My colleague is going to post a link to a quick feedback survey. If you could spare 2 minutes, it's literally 2 minutes, to help us improve these events. We know that we have to look into the cameras issue for sure. We've been trying different options. It looks like we might try something else next time. And also a link if you want to keep up with our work, then sign up to our newsletter. There is also a Google group where you can get in touch with like-minded researchers and practitioners on modern slavery, ask a question, discuss things. Again, thank you very much for attending. Alicia, thank you very much for presenting, and on to the next one. Thank you.